Good morning. We're privileged to have the chance to speak to Don Klawiter today, one of the best known antitrust lawyers in the country. Don, it's a privilege to have a conversation with you.
It's a privilege to be here, John.
There was a time before antitrust for Don Klawiter. Why don't you give us a brief summary of Don Klawiter, the early years?
Well, basically through high school and college, I spent a great deal of time debating and spending time, trying to hone my skills, not knowing or not having any clue what I would be doing after that. But it's very interesting to look back at that now, since many of the leadership of the antitrust section did the same thing. Mike Denger was a national champion debater. Joe Anglin was up there. Various people, Bob Joseph, Bill Kovacic, did it as well. So from that came a desire to want to do something in life that involved public speaking, that involved analysis. And I didn't want to do anything that was all that simple, so I was looking for complexity, and I certainly found it in the antitrust world. But there was a time when I was thinking very seriously about going into a graduate history program and being a historian. And somewhere along the way that got derailed, and I liked the idea of the courtroom, I liked the idea of the analysis. Ended up in law school and found a professor by the name of Louis Schwartz, who was one of the great renowned antitrust professors, and started to work with him. And the next thing I knew, I was working for the antitrust division the second summer of law school, and decided to stay and had a really great time while I was there.
Say a word or two about Lou Schwartz, because he's one of the giants of antitrust in those years. What made him so special?
He really was somebody who was sort of jubilant about the antitrust laws and what the antitrust laws did. In many respects, he thought the antitrust laws should have been stronger. There should have been more opportunity to clamp down on companies. When we were talking about mergers at what point, he made a comment which was essentially, when in doubt in a merger case, divest. So he was really a hawk and really a very strong advocate. Had spent time in the antitrust division when he was a young lawyer as well, and really kind of reveled in the enforcement side and thought that was really what it was all about. And I just enjoyed his classes thoroughly. He brought economists in. I remember Oliver Williamson, a recent Nobel Prize winner, coming to class, and Lou Schwartz to some extent mocking him a little bit because economics was not yet the thing, but it was fascinating, the interplay. Elmer and Phillips was another one we had, who was at the Wharton School at Penn, and he too taught at the law school, and the confluence of all these things obviously had made an impression, and I never looked back.
So fast forward now, you find yourself walking in the doors of the antitrust division. Where were you at that point, and what were you being asked to do?
I started, as I said, I worked the summer at the antitrust division, got an offer through the honors.
In the Philadelphia office?
Yeah, the Philadelphia office. Came in through the honors program and went to the Philadelphia office, where there were just an enormous array of grand juries and criminal cases that were in process. There were also merger cases at the time. The field offices did everything. So we did a merger one week, a cartel investigation the next. And I was very fortunate that one of the first cases I did, and literally I started in the grand jury the day after I was admitted to the bar, because you couldn't go, and so we basically rushed the paperwork through because there was a grand jury session coming up and they wanted me there. We started with a case that's been known as the Consumer Bags case, U.S. v. Continental Group, which we took through the investigation. It was right at the time when the law had changed, where a Sherman Act violation was now a felony after December 21st, 1974. And I remember that date vividly because it came up in court probably a couple of hundred times in the course of this case. But what happened is we had a course of conduct which continued into the felony period by one set of meetings, but a whole variety of the conspirators were not at that meeting. So the events as they related to them ended before the date of the felony statute. So we ultimately indicted twice. We indicted a felony case and a misdemeanor case. Same facts, but one ended sooner than the other. That case, because it was a felony and because there was great outrage on the part of defense counsel, went to trial.
Now, how long did it take to get to trial?
It took about, I think it was about 8 months or so. It was not a long period, and we had, very intensive discovery. We had a great grand jury record. This was the time when you put literally every witness in front of the grand jury. And so that record was there and available to the defendants. Some of them pled out, but a large number ultimately went to trial. And the trial was just one of these magnificent experiences.
Now, were you leader of the trial team?
I was leader. I was working with 2 senior guys, but they didn't want to really do anything or not do a great deal of the work. So I opened, I closed.
So you were lead trial counsel?
Yeah, I handled the economist. I handled the chief witness. We had a great trial judge, Lewis Bockius, who in Philadelphia, who was just wonderful. As long as you were obeying his rules. If you were not obeying his rules, he would get a little cranky, and fortunately that was mostly on the defense side. But it was, a classic cartel, went on for many years.
How long did it take the jury to come to a conclusion?
The jury was out for 3 days, and in fact the interesting part of it was they came back on the day before Thanksgiving. And only after at lunch the judge asked them where they were in their deliberations, because if there was a need, the marshal would get turkey sandwiches for all of them the next day, and that sort of captured their attention.
Move them along a little bit.
They were back within, I think, an hour of that little conference with the judge. Convicted the companies, individuals. Just a great experience for a 27-year-old who had no clue how serious this was, and as I said, if I knew what I knew today, I would have been frightened to death to do that. But at that time, just went with it, did it, and it, the result came out very well.
And I think it's fair to say, at least within the division, that case made your reputation. And after that, Don Klawiter was the person who had tried the first felony case and won it. And that led to a whole succession of events. Say a little bit about what happened next.
Well, the next thing that happened is I was asked to apply for one of the positions in operations, special assistant to the director of operations. I came down to Washington.
Those people are known as pups, right?
They are known as pups.
What is that? Is it a dog's life or what?
Well, I think it had a dog relationship at the beginning. As I understand the lore, when Bud Rashid, who was sort of the quintessential director of operations before my time, and Bob Hummel was the deputy director, they would joke around with the section chiefs, and there was this one section chief by the name of Hugh Morrison, who we know very, very well and was one of the truly great ones. And Hugh said one day, he said, well, Bud is the top dog, Bob is the deputy dog, and those 3 people that roam around this office all the time are the pups. So that's how, pup became, a term. Hugh also named everyone when they came to operations. You were escorted into his office and he gave you a nickname, which usually stuck.
What was your nickname?
Claw.
Klawiter.
In fact, what Hugh used to do at meetings would be when he wanted to call me, he would just go like this. And I knew what he meant, but a delightful, wonderful man.
Now, what was operations meant to do, and how did you fit into that overall operation? Operations
was really, at the time, the kind of the center of the division's activity. Everything flowed through operations, both up and down. If a section wanted to open an investigation, it came through operations. We would do an analysis, send it to the director. If there was a case recommendation, same process, although we then send it to the Assistant Attorney General and kind of move that process along. You had paperwork on each end. Each of the 3 pups had 6 sections that they were responsible for, a combination of field offices and Washington sections. And the amount you learned in that job was unique. I mean, it was just unsurpassed anywhere else in the division. You saw all the cases come through. You had, the opportunity to tweak them, help them, discuss them with various people. And we had a lot of other duties, really keeping the sections and field offices informed of things, let them know what is going on in the division, work very closely with them. It had to be just one of the great jobs of all times because, you were there all the time because, the workload was so intense. During the time you were Assistant Attorney General, there were a lot of other projects, the division manual for one, that
say a little bit
got
about,
involved in.
I remember this extraordinary young man across the hall who was supposedly working 90 hours a week, volunteering to do more work. Say us a little bit about the Antitrust Division Manual, because that was an interesting project.
At some point, we were trying, in the course of dealing with all the sections, you said we really should have something more they can look at. We have a reference guide, have some process in there to deal with. And we looked back, and there was a very, very old manual which covered some topics, and we had the idea of, not really updating it, but kind of redoing it. And so in the course of about a year, we were able to pull together all the policies, statutes, procedures of all sorts for the division and put them in a binder of 6 or 7 sections. I got some of the sections to write, sort of what we would today call best practices for how to do certain things.
And you really stepped forward to become editor of the thing, as sort of a chief aggregator and editor.
Exactly, and there were times when it was just a huge project and we never thought it would get done. It was also in an age when we just had typewriters, and the mag card typewriters were about as state-of-the-art as you were going to get, and so secretaries were literally typing it on these mag card cards and then converting it into something.
Tell me, Don, does the operations office today play that kind of a traffic cop role?
I think it's more diffuse today. I think they have some of those responsibilities, but I think things have gotten more specialized. In the criminal area, for example, the criminal deputy has special assistants who are really devoted and dedicated to the criminal enforcement. That takes some work away from the pups. And I think it's diluted is not quite the right word, but it's not as all-encompassing, I think, as it was back when we were doing it. But again, just a wonderful, wonderful experience.
But then you stepped into a wholly different sort of phase of life at the Antitrust Division and became a section head or a field office head.
That, again, was a very interesting moment. One of the offices I handled as a pup was the Dallas office. Dallas was having some difficulties transitioning from their very great chief, Barry McNeil, and the person who came in after Barry was, in conflict with the staff all the time. So as the pup, I got a lot of the sort of commiserating, working through, trying to figure out how to do things. They had very little work to do, which exacerbated the problems. And so Sandy Litvak called me into his office one day and said, "I want you to go to Dallas." And I said, "Sure, I've never been there, look forward to the trip." He said, "No, you don't understand. I want you to move to Dallas and run the office." I was 30 years old at the time. Again, things moved very, very quickly through the bag case and operations. But I literally showed up, very little work to do, and we decided that this was the era of road building. And believe it or not, there was no road building case or no road building investigation in Texas, which has more miles of roads than any other state in the Union. So we opened that, and literally within the first 9 months, we had, I think, 19 indictments, had a whole staff working on it, brought in DOT people, and it was really a great success. And the office came back strong and remains there today. So I'm very, very proud of that situation, and I think we did that very well.
Do you like being in charge of things as opposed to being an advisor?
Yes, I think very much so. I mean, that was an opportunity, again, great creativity, because you were kind of starting over opportunity to, work with the staff, to bring people in, to bring them up to certain cases. And I think the people who were there enjoyed it and had a very, very good time. But
it's a challenge to walk in as a stranger from Washington into a field office like that and to make any sense at all and take control.
Exactly.
Did you have tension to begin with? Or?
I was welcomed very well. I mean, I think there was a little tension with a few people, but most of the senior folks in the office who I'd gotten to know were very, very good and very happy to have me there. And we all became very close friends and spent a lot of time together, which again kind of added to the camaraderie and the enthusiasm that the office then had. But it was a great experience. I didn't want to do it for a long time because a boy from Philadelphia felt a little uncomfortable occasionally in Texas, but I got over that.
The Antitrust Division as it exists today, you think it'll be the same in 25 years? Field offices, sections, is it going to be the same size? Will it be active? Do you have any sense of that? Any predictions for the future?
Well, I think in terms of predictions, I would say that I think it will be there, it will be active. The structure, I think, may change in large measure because of technology and how things are being done. When I was the chief in Dallas, we had a 4-state responsibility. You never really ventured out of those 4 states, or somebody else would have a shotgun and be after you. Nowadays, I think things are much more national or international. Offices in New York are doing cases in the West. The offices in the West are doing cases in Florida. I mean, there's a great deal of that. So I think it's going to be much more, I don't know if virtual is the right word, but people can do things anywhere. And I think the rest of it really depends on who's in charge and who's formulating policies. I mean, one of the policies I see changing to some extent is the way that the Antitrust Division and the European Commission and others treat information exchange or collaboration among competitors. We're seeing a great deal of that now, and I think we're only seeing the beginning, and I think over time that's going to be much more of an issue as the hardcore activity subsides to some extent, or at least goes underground. I think you're going to see much more of the economists trying to figure out cases based on economic theory and game theory. We've seen some of that, but I think not anywhere near what the potential is. So I think the division will be there, will be vibrant, and just needs good leadership and good folks to go out and do these cases because they're there.
Do you think cartel enforcement will remain at the forefront?
I think it will, and I think people have been debating over the last year or so whether the number of cases has decreased in recent times. Yet when the big ones come, they are pretty overt and pretty direct, even after 15 years of very high fines and all of that. So I think human nature allows us to predict that there will be cartel cases for many years to come.
So you're down in Dallas and you're running this office, and then in the twinkling of an eye, you've left the government. Talk a little bit about that. Had you always anticipated going into private practice, or was it a new idea?
Well, when I first came to the division, I thought, well, this is a good place. I'm going to learn a great deal. 3 years and I'll be somewhere else. After 10 years, I mean, the sort of fun that came from, the Philadelphia job, the operations job, and Dallas. And then afterwards, I did some merger work, which was a lot of fun as well. But there were the moments when you were saying, maybe it's time to go, and there would be a few nibbles here and there from people, but I stayed because I was having a great deal of fun. Then ultimately there came an offer I couldn't refuse, which was actually spring meeting week of 1986, when you called me and said you had just changed firms, and was I doing anything for the next 20 years? And again, that was, I thought, a very easy transition to practice at Morgan Lewis and building the team that we ultimately built, which was just spectacular. And the cases we handled there were just extraordinary cases in their own right along the way, from night court to the Etsy case to the whole criminal cartel development internationally.
Yeah, let's take those in order, because each of them is sort of a whole story in itself. I remember when you spent a winter in the snowy wilds of South Dakota.
It was a very long winter. I think we went in January, we came back in April and had this extraordinary trial against the state of South Dakota between or in front of a hometown judge with hometown plaintiffs, with hometown jurors. And at trial, although I think we put on one of the great trial shows of all times, the jury was having none of it and decided that our client was liable for $600 million. Fortunately, there
Which
was...
in those days was
real money, exactly. And then we took it to the Court of Appeals, to the Eighth Circuit, where you argued brilliantly, and we put a lot into that. And the court not only reversed the decision, but dismissed on several independent grounds. So in case the plaintiffs thought they could get through one of them, I think there were 3 or 4. And then a footnote saying, and we have not even gotten to these other issues, which again was one of the great superb victories. Made it worth spending 3.5 months in South Dakota in the wintertime.
But should it ever have come to that, I guess, is the question. What was it about the complexion of circumstances that led a case to be tried in front of a jury, every one of whom was interested in the outcome, because if they won, if the plaintiffs won, the jurors would stand to collect some money?
Mm-hmm.
I mean, that seems like a pretty fundamental flaw.
I think it was a fundamental flaw, and I think at several junctures in there, the Eighth Circuit, kind of did not take the appeal or the mandamus, which I think in retrospect they would probably even look at it and say they should have taken it. Mm-hmm. But again, busy courts, clogged dockets, the view was, well, that's a problem, but let it go to trial and see what happens. And that's a very expensive proposition, and it was in that case. But
it caused millions of dollars of expense, which at the end of the day turned out not to be particularly worthwhile.
Exactly right. Exactly right.
So then there was night court. You had an antitrust case in night court. That sounds like a contradiction.
It was fascinating. We were representing Fox and Fox's subsidiary company, Deluxe, which was one of the 2 major film processors in the world for the motion picture industry.
Right.
The Antitrust Division brought a Section 7 case against the Fox and Rank, which was the purchaser. And we drew a judge, and we went to see the judge, and he basically said, I'm booked solid. This was going to be a preliminary injunction case. He said, I'm booked solid. Sorry, this sounds really interesting, but I've got a Colombian drug cartel case in my court for the next 4 months. And as I recall, when we were leaving, the judge said, well, how long do you think the trial would be? And we said, well, we could probably do it in 2 weeks. And he said, well, I'll tell you what. And he said, if you agree to start the trial every evening at 6 o'clock and go to what he referred to as the witching hour, I'll try it for 2 weeks in my court. So we had literally night court in Los Angeles, where we started at 6. We took 1 break in the middle of the evening, 9:30 or so, to have dinner. The government counsel and defense counsel had dinner together every night and got along extremely well. And at midnight, the judge would kind of call it quits. Mm-hmm. And we got all the witnesses in. We, I think, put on a very, very good case, and ultimately won the decision. The judge denied the preliminary injunction, let the deal go through, and it was, again, a great victory and a great result.
But as a trial lawyer, where you have to line your witnesses up, you have to say, it may be another hour, but you're going to be on today. Mm-hmm. How do you do that when it's 9:30, 10:30, 11:30 at night? People are getting tired and sleepy.
That was a challenge. And again, we had a few witnesses who we were worried about being, sleepy or tired. And again, just tried to manipulate the process. I remember the president of Deluxe came on at 11:15 one night, and I'm thinking, oh my goodness, you know, but he did extremely well, and it went beautifully. It was all timing, and in fact, one of the great things about it was that the judge had no interruptions that he would have in a normal court day where somebody needed a motion to be responded to or set a schedule. The judge is always out of the room. He was on that bench except for that half hour or so we spent. So the efficiency of doing it that way was phenomenal.
But what an extraordinary performance by the judge to try a drug case all day, get a sandwich and a cup of coffee, and then start a whole antitrust trial.
Well,
what was the name of the judge, do you remember?
Terry Hatter. I remember his remark at the end of the case. He said, it's a bad reflection on society that the drug case that I'm trying during the day has a greater volume of commerce than the antitrust case I'm trying at night. And that was very true and very, very amazing. But I mean, the great advantage in the case was we got to prep our witnesses all day long. It was not that you were prepping them at night. You sort of reversed the process. And
have you ever heard of anything like that anywhere else?
No.
No.
Have not seen that.
In those years, I remember more and more you were beginning to focus on cartel work, and particularly the international cartel work. And we're very successful at it. What triggered that, and how has that been over the years?
Well, the Antitrust Division, I think for many years was trying to do some, more international cases. It was very difficult for a variety of reasons, principally getting evidence and getting witnesses. As the 90s went through, they made a couple of attempts at it. The fax paper case, the GE Diamonds case, which was just an unmitigated disaster for the government because they couldn't get the evidence or the witnesses. And then they happened upon the ADM case and Mark Whitaker and all the lore that goes with that, and got ADM to plead guilty and pay $100 million as a fine. Nothing like that had ever been done before. In fact, the year before, the government was saying, our limit is 10 million, we can't go higher because that's what the statute says. Now the process changed completely, and we were in this mode of huge fines based on twice the gain, twice the loss, rather than the statutory number. And the $100 million fine really opened up the whole process. Indeed, the leniency program, first one was 1978 program that you put together at DOJ. And then it was revised in 1993 when Ann Bingaman was AAG. And for a couple of years it sat pretty quiet. And then when this $100 million liability issue was out there, people really did start to swarm into the door and get leniency, and that really started the whole effect of it. The fascinating thing was the government was, I won't say making it up along the way, but creating a process, law, procedure. How do we get these individuals to come to the United States and be witnesses for us, but also plead guilty? And the government was ingenious at finding ways to do that. First, the leniency program, which would give everyone a free ride. The other was they worked out a deal with at the time, Immigration and Naturalization Service, where individuals who pled guilty for a felony who cooperated would be allowed to come back to the United States and conduct their normal business. And that was a great opportunity. Leniency Plus came after leniency. And
Say what that is, leniency.
Leniency Plus is you get caught in one matter, you're going to plead guilty, but you bring to the government conduct in another product area that your company is involved with, and you get the same kind of leniency, no fine, no prima facie effect, and no jeopardy to the individuals who cooperate.
But you and I both know that the government by itself can't change the system. It can sort of try, but unless there's some intelligent response at the other side, it won't make that much difference. So surely defense counsel had a hand in creating this system. Is that a fair conclusion?
I think that's fair, and again, it was a point of time when there was great cooperation on a policy level. And part of that goes into some of my ABA work, where we essentially set up task forces that government talked to defense lawyers. We talked about things that bothered us on either side. Policies were changed. Something like Leniency Plus came about as a result of, here is the case that is going to, if you want to do something like this would be very valuable. And indeed, I remember those conversations. Why don't you take for the second case, if the company's coming in and cooperating fully, give them a pass on that. And the government went one better than that. They said, we'll give them a pass on that, and we'll also give them credit against their first fine. So we're really sweetening the deal. And once that process started, by the late 90s, it was kind of in full bloom, and there were just an extreme number of cases out there, all international, involving nationals from a number of different countries, and the rest is really history.
$100 million does tend to concentrate the mind, or avoiding it tends to concentrate the mind. To what extent has the U.S. model of criminal enforcement of the antitrust laws been adopted elsewhere around the world? Is it at all, or some, or a lot?
It's more and more all the time. It's fascinating because there are some jurisdictions which say, this is a civil regulatory violation, we will treat it so, the EC, for example. But many of the other countries around the world have looked at the criminal model and said, this is where the deterrence is. Paying a corporate fine is nice, but it's not going to get people to stop doing this. The CEO going to jail is. And so we've seen more criminalization. The UK, Germany's done some of the other European countries have started the process. Brazil is doing it in a big way. Japan, Australia just passed their criminal law. And everyone's sort of trying to figure out the right balance, but the idea is this is how you get people's attention. And, I mean, we've had cases now where people have been charged criminally in 2 different jurisdictions. The Marine Host case, and went to jail. They were UK citizens, and they ended up serving their jail time in the UK, although they were sentenced in both the UK and the United States. So that has just come an extraordinary way, but a lot of it really had to do with the cooperation between defense counsel and the government enforcers.
So what you're saying is it's possible to get hammered in the UK, in the US, and maybe elsewhere. Would it make sense to think about having a prime enforcement agency for each matter and just focusing on that agency, or does the split responsibility really make sense? Or does it make a difference?
I think they're still sorting that out, and I think, there is a tendency to say one should really be the lead, but again, depending on what countries want to do with their policy. And the UK and Marine Hose, that was a very interesting development because they were just getting their criminal law off the ground. So, that made a huge difference in the enforcement. I suspect people will not be criminally prosecuted and sent to jail in 6 jurisdictions over a period of 20 years. I think there is going to be more work there, but I don't think that's all completely sorted out yet. But Marine Hose gave us a sense of how they're thinking about doing it, at least.
So you have the enormous South Dakota case, this amazing California night court case. You have the criminal enforcement and the blossoming of that whole area of the practice. The other thing I remember you doing very well is stepping into the antitrust section of the ABA and beginning to build a record of real achievement. And you eventually became chair of the section.
Yes, I did.
What is the role of the antitrust section? What good is it?
I think the antitrust section does several things. I think the first is it is an opportunity for antitrust lawyers around the world now to get to know each other, to work together, to share ideas. It is also the largest publisher of antitrust materials in the world.
Interesting.
And finally, it is the, I think, largest conveyor of programming of one kind or another in the antitrust world. And again, working cooperatively with the 2 U.S. agencies, which again, is critical to the process, as well as now more and more of the international agency, the other countries around the world. It's just been extraordinarily helpful to develop that. I mean, one of the issues is we found as business gets more sort of entrenched in law firms, training is not going on as much at the law firm, so that role really falls to the section in a very, very good way. And there's a lot of programming that the section does that is free to its members and is really extraordinary. When I was chair, we worked on that initiative to make all these programs available on the internet, on the website. Great stuff out there. But I think the teaching side, it is also an opportunity for the government agencies to basically convey their message. And a lot of what we did on the criminal side was, again, cooperative work between
went through the
DOJ and the section.
Interesting.
Including all the great programs, the cartel programs we've done over time.
I remember, though, those years being years in which the antitrust section produced really valuable comment on leading issues of the time. For instance, there was a commission to look at revising the antitrust laws, and the antitrust section produced, I thought, very valuable comment, and I think that was during your time as chair.
Yes.
How did you get that together?
That was an interesting feat because the section over the years had commented mostly, say, if the European Commission put out some sort of paper, other jurisdictions, sometimes the U.S., we had commented on legislation. But getting into commenting on, kind of substantive issues that were under the microscope at the time with the Antitrust Modernization Commission was really something reasonably new and different for the section. And what we did was assign a number of the committees of this section to take responsibility for different topics. And over the course of my year as chair, we filed, I think, 26 or 28 sets of comments, most to the AMC, but to Europe. I mean, we dealt with the European private actions. We dealt with unilateral conduct in Europe. Plus, I think now if you take the binder of all of those comments, it looks like an antitrust treatise because you cover literally every topic there is. We did the criminal stuff, we did the unilateral conduct, the mergers, exemptions, all sorts of things. And we were able to pull together lots of people who had great enthusiasm for these areas.
And experience.
It's
not just an academic exercise.
It is not anywhere near an academic. And in fact, the value added this section believes it has is all these people who have done these things and have had these experiences are conveying their, knowledge and experience to, here it was the Commission, but it's also European Commission, it's the Canadians, it's Japan, it's Korea.
But surely it must creep into your mind, and certainly crept into mine in reading the comment. Am I seeing here the not disinterested views of a private lawyer who is in fact representing a client in presenting this? Or is this the best policy judgment that this committee can produce? How do you guard against self-interested pleading of that kind?
Well, I think there is such a review process within the section. A committee does it. It goes up to the council. The council sort of scrubs the document, works through it, finds things like what you're referring to make sure that what we're sending is balanced and unbiased. And for the most part, everyone in the process knows that that's what they should be doing. We are looking at policy. We are not looking at a client's interest. And it has usually sort of, there have been battles and debates on these things all over the place. But I think at the end of the day, what you're getting is a pretty balanced, policy paper based on experience, really in both directions. People will sort of talk about the good and the bad. And I think that makes these papers very valuable to certainly to the AMC.
Yeah, what was particularly fertile about that process at the AMC was that not only did we get papers, but then the section sponsored witnesses, and we could cross-examine them. You know,
Right.
Why did you say this? Why didn't you say that? And almost uniformly, they were very high caliber. Did you play a role in picking those people, or how did that work?
Well, we looked for volunteers, but we basically selected them, and coming up to, you know, the committee structure, you always had a chair there who had a responsibility, and then it went from there to the council, and it was, a lot of the debate was at the council level. And in fact, when I kind of left my year as chair, we looked at the number of hours the council had met that year, and it was like twice what it had been any other year. So
Were you the most popular person in the Antitrust?
I'm not sure if I was most popular or most, oh no, another set of comments, what is he doing to us? But you know, that comment function has really taken on a life of its own, and it's continued very, very well, especially with the, you know, jurisdictions around the world that are doing a variety of changes to their policy.
Is the antitrust section membership constant, or is it going up or down?
I think over the course of years it has gone down slightly.
Why do you think that is?
I think just, you know, I think the people who are really interested in it are going to be there all the time. I think it's the people who, you know, I'll join 2 or 3 committees or 2 or 3 sections, and then they say, well, you know, I don't know if I'm really, you know, using this to full advantage. But it's relatively constant. And
How many,
I mean,
roughly?
I think we were, you know, 9,000 or so.
9,000. That's
When I was chair, I think that's where it was. And again, the leadership of the section is well over 300, and these are the people committed to, you know, doing the work and doing the papers and putting out the newsletters and putting out the books. And it's just a phenomenal experience to have all these people, you know, working very hard on policy, not on their clients, to try to get it right. And I think that's one of the great advantages the section has for
When you were chair, if you think back, what is that, 5, 6 years ago, something like that?
05, 06, yes.
05, 06. Of your working day, do you have a sense of how much of your time was spent being chair of the section? Any rough notion?
I mean, my sense is it was about 60 to 70%. I didn't think it would be that high, but it was, in part because we were dealing with all these comments, dealing with sort of a heavier programming load than we had most years. It's interesting because when I first started to do things in the section, I got involved with the criminal committee, which was, again, right at the time that international cartels were building up. And I thought that was, you know, the greatest thing I could ever do. And Kaz Hobbs, our former partner, who was chair and was sort of guiding me along, at one point came in and said, "You've just been elected to the council." And I remember looking at him and saying, "But Kaz, I want to be chair of the criminal committee. You know, I don't want to give that up yet." And, you know, it was just great stuff. But being chair was extraordinary, and I never thought I would aspire to it. I never thought I would enjoy it, but I enjoyed it thoroughly. And I think we just got to do a lot of very important things, and I think did them very well.
I'm trying to remember, did you have a hurricane and floods during your time, and how did that affect your role?
At the very beginning of my term as chair, Katrina happened. And so New Orleans was in trouble. There were all sorts of things going on. And we got together sort of on an impromptu basis with the officers and some of the others and said, you know, we've got great reserves from the section. We have a lot of money at that point in time. Can we do something, and what can we do? And I deputized Alan Van Fleet, who is now the chair of the section, and who was from Houston and, you know, more directly affected by it. And I said, Alan, what can we do for these people? And we ended up donating a fair amount of money, plus helped put together for the public television stations down there a primer on what people can do to get their insurance claims taken care of, and what, you know, sort of the legal things that could help.
This was just completely pro bono.
It was completely pro bono.
Excellent.
And the section did it. A few of the other sections also contributed heavily, but I think we were at the forefront, and Alan did just a wonderful job of making all that happen.
Mm-hmm.
It's a little out of the ordinary from what the
very,
section does, but
very
it was,
much out of the ordinary. How do you see the antitrust section 25 years from now? For instance, does the internet, is that going to make a difference?
the internet has been making a huge
Has
difference.
already. Mm-hmm.
And the amount of material you can put on the internet have available to the members, and again, we would refer to it as a member benefit. But these brown bag seminars that I talked about a little earlier, we decided to put on the internet, the electronic version, so you could put it on your iPod or listen to it online. And so virtually every one of these, and there are each year 50, 60, 70 of these programs. You can learn all the antitrust law you want by just clicking on that website. But I think the internet is making a huge change in how the section operates. Programming is, I think, less and less going to be live programming, except for what I would refer to as the big events, the spring meeting, the cartel program that we do, a demonstration program for 3 days every 2 years, the fall forum, which is I think those will stay where they are and are well attended. I think other programming is going to be on the internet and be by these little pod things or whatever we're doing. But that's created, I think, great opportunities for the membership of the section to get involved more so.
We have just a few moments left, so I'd like to ask you a sort of a concluding question. Now that you have gray hair and you're a senior person in your profession, talk to a young lawyer that's watching this. What would you advise a young lawyer to do who might be interested in following in your footsteps or having the same kind of career?
2 or 3 things, I think. The first is to really learn the law. I mean, antitrust law is so rich in terms of, policy and law and, effects on people ultimately around the world. But, you can't do that by simply, handling your client matter. You have to get out there and read the cases. There aren't that many of them ultimately that are really quite important, but you really need to get involved in them. You should, read other things that relate to, kind of the legal world. And in fact, when I chaired the master's course, which is the big course for the younger lawyers, back last fall, we gave them a reading list of things. These are things you have to read. And it was antitrust treatises, it was antitrust books, The Informant, but also things about the profession to kind of, you've really got to know that stuff or you're of very little value as you go forward.
What would number 2 be?
Number 2 would be, at some point early in your career, get involved, get into the government. Spend a few years at the Antitrust Division or the Federal Trade Commission. It's just an opportunity that you should have and is very valuable for most people. Not everyone can do it, but again, given my experience of falling into serious cases, then going to operations, I mean, you just learn so much that you're not going to learn anywhere else.
What would number 3 be?
Number 3, I think, is get involved with the section, because I think, again, supplementing number 1, you can learn things, you can meet the right people, you can form great friendships, but there is just so much substance there for you to learn and to be exposed to and to have at your command that I think any young lawyer should get involved in a writing project or the program or the comment process, which many of them are. And I think those 3 items are really what would make, sort of make a career and put you in the right place. I wish I could let you keep going, because this is a very, very rich conversation. But the young lawyer out there ought to pay very close attention to that advice. Don, it's been a real pleasure to speak with you, and look forward to the next generation of discussion. It's a great pleasure for me, John. Thank you so
very
much.